All right. Welcome, everybody, to this webinar by NAPSA, the National Association of Pretrial Services Agencies. We are super excited to have you here and have you join this session, which I'll talk just a little bit more about here in a second. My name is Wendy Venverlo. I'm the Executive Director of NAPSA, and it's my pleasure and honor to be here with you today and also to be with the panelists that we have gathered to present this session. I just have a couple of housekeeping things to talk about first. First, you'll see at the bottom, there is a Q&A section. That is where throughout the webinar, if you have any questions for our panelists, you can put those questions right down there and they can answer them either by typing an answer or verbally while they're giving the presentation. So any questions you have, please put in the Q&A below. You also, I see several of you guys welcoming each other and saying hi to us. So appreciate that in the chat. So you do have the ability to chat with everyone and chat with the panelists if you want to do that there. But again, please put all your questions in the Q&A. This session we will have uploaded to our YouTube channel within the next couple of days following the session. And so you can look for that there. There'll also be some notice sent out via email about the video being uploaded to YouTube. In the future, we're going to continue to have these webinars. We're scheduling them at this point through August. The next one that we are going to have is going to be May 21st. I will put that registration link in the chat here in just a second, but it's May 21st at 12 p.m. Central Time, and that will be on NAPSA accreditation. And we have some of our accreditation commission members who are going to be there to discuss that. So if you've ever had questions about accreditation, wondered what it is, how it works, that's a really good session to attend, May 21st at 12 Central Time. In addition to that, something I'm super excited to mention is that we have a fall conference coming up. I think you probably all know that. That's September 14th through 17th in Atlanta, Georgia. But we will be opening registration for that very soon. So I would expect that sometime in the next couple of weeks. So please keep a lookout on our website, which I will also put in the chat. Keep a lookout on your email, on social media, because we will be putting in all the information about registration and everything we have going on with our conference. So all of that being said, I'm again super thrilled to have you all here today. We have a session that was developed by our education committee. And I'm very happy to turn things over to the chair of the Education Committee, Aaron Johnson, who will start us off.
Very good. Thank you, Wendy. My name is Aaron Johnson. I'm the current education chair for the NAPSA Education Committee. I'm also the Texas Association Pretrial Services president. In my full-time job, my actual job, I'm the current director for personal bond and the magistrate court in Galveston County, Texas. So with that, I will turn it over to Melana.
Hi, everyone. My name is Melana Gross, and I currently serve as a manager for administration and development for Kentucky Pretrial Services, where I have been for the past 21 years. And now I'll pass it to Domingo Corona.
Hi, everybody. Domingo Corona. I'm the treasurer of the NAPSA board. My day job, though, is pretrial services director in Pima County, Arizona, and I've been with pretrial for, it'll be 27 years in August. And it's my pleasure to turn it over to my esteemed colleague, Janice Dean.
Thanks, Domingo. My name's Janice Dean. I am the current Northeast Regional Director for NAPSA, and in my day job, I am the Criminal Division Administrator in Pittsburgh, Pennsylvania. I oversee Criminal Division, Pretrial Services, and Adult Probation. And I am going to turn it over to Hillary.
Afternoon, everyone. My name is Hillary Hartoin, and I am the Court Services Director in Cass County, Indiana, a rural community in the heart of the state. I oversee a treatment division as well as pretrial services. With that, I'm going to go ahead and just kind of dive into our session about pretrial's role in jail population reviews. And today you're really going to learn how to leverage that data and use it to make some meaningful decisions to impact your pretrial system. So as we get started, we really want to get to why it is important to review your jail population data, not only for you as a pretrial director or a pretrial officer, or maybe even the chair of your CJCC, but for your system as a whole. But your local jail is really, I call it, it's my pulse point of my local criminal justice system. If I want to take the pulse of how we're doing and see how we're doing, I look at my jail population and who's in there and why, because that helps me identify areas where I can make improvements. So look for key change targets. And it's also a good way to reflect at your current practices and your decision making. Often stakeholders' perception of who is in my jail and why, especially my judicial officers, is different from reality. And when we talk about that perception, Domingo has a really good perspective give from his work in Pima County in their jail review.
Yeah, so appropriately enough, I'm at the MacArthur Foundation Safety and Justice Challenge convening in Chicago as we speak, and one of the things that we started with the foundation's work and looking at jail populations was an assessment, an initial assessment on who was in our jail. And when we first started the challenge, and I just like Hillary, like our pretrial organization was very familiar with jail population, and we kind of knew who normally was being held at initial appearances. But what was interesting to me was the stakeholders' perception of who was sitting in jail. It was the thought that we mainly had low-level misdemeanor cases that were being held and not released pending a money bond. But in fact, we kind of had an idea that it was felony cases that made up most of our jail, which national jail data usually supports. So, it was interesting to have these conversations with our stakeholders at the beginning, to hear them talking about the fact that, we wanted to release more of the low level, misdemeanor cases. And, we were trying to preach to everybody that that's really not the population that we have sitting in jail. As it turned out, the felony drug population and high risk, high level cases were those individuals that were sitting in jail. They made up about 2/3 of the population at the start of our challenge. So I thought that was a good exercise for us to engage the stakeholders and correct some, not correct, but just educate on some perceptions as to who was sitting in custody.
Thank you, Domingo. And we follow that same practice here in Cass County. We do monthly jail reviews, and you'll kind of see what a little bit of what that looks like towards the end of the session. But our stakeholders have really developed an appetite for that jail data, because they realize that it's an accurate reflection of who is in the jail, and it helps them examine their sentencing practices, but also their release decisions. It's a measure of your jurisdiction if you're maximizing release and you're really utilizing your community-based alternatives to incarceration, and if they're being efficient in controlling that jail population. And for us, mainly that's for pretrial programs, but we also can use it for your CJCC when you're looking at the effectiveness of your treatment courts or of community corrections. But the key is of why it's important, as Domingo says, it drives that meaningful discussion, and it gets you examining your system processes and helps you identify areas that you can target and work on, because we all know that we want to strive for that continual change moving forward. If we talk about that, and you've heard Domingo and I talk about a team, jail data really should be examined by a population review team. If we could move to the next slide. While jail data alone is able to provide us insight, we don't want to make assumptions based on that data, and it doesn't tell the whole story. So it's really important to have all your stakeholders together in a team to provide some context about who is in the jail and why. Maybe there are some processes or some duplication of services, or there are little hiccups in the system that we can smooth out and make more efficient. And we can't do that if we don't have all our stakeholders together at the table. If you have a local criminal justice coordinating council, this is the perfect body to use to have these type of discussions and to look at those different policies and to measure that efficiency. One thing to think about is that jail populations are constantly changing, and whether that's an urban county like Pima County, and Domingo will talk about that here in a minute, or a smaller county like mine, from week to week, that jail population is fluctuating and changing, and that dynamic is always changing. So that's why it's important to have a continual review. And with that, I'm going to have Domingo give a little bit more about how he has seen the jail population turn over.
Yeah. Absolutely. So, one of the things, and I mentioned, I'm going to kind of stick to the story around our work with the MacArthur Foundation's Jail Reduction Challenge. But one of the things that we found, because we did an initial jail snapshot, and looked at our jail population, and then, like I said, we saw that there were some, it was, mostly felony cases, and some of those programs around felony cases were going to take a little bit longer to implement. And so, we knew that, for that population that was higher risk, or, individuals that were charged with possession of drug charges, we had certain strategies that would take some time to implement. So we did the initial jail snapshot. It was going to be super important because some of the, what everybody likes to call the low-hanging fruit, was that smaller pocket of misdemeanor cases, low-risk misdemeanor cases, that were failing to appear, and they were coming in on a warrant. And I won't get into strategies around, what we did, unless we're going to cover that later in Q&A. But essentially what happened is that, we were able to address some of some of that low-hanging fruit population, the misdemeanors that were coming in on warrants. We were able to release those people pretty quickly through a process, So what happened is that about a year in, or a year and a half in, after follow-up review of our jail population, we found that the misdemeanor population was starting to reduce, and eventually it was a small component of our jail's custody population. That meant that we had to kind of focus a little bit more on those longer term strategies that we're still kind of working on now. So it was very important for us to keep reviewing the jail population as we went through implementations, especially for some of those cases that don't stay that long in custody, like a misdemeanor case. The average length of stay for that population was shorter, so we were going to have some more immediate impacts, and we needed to make sure that we follow the data when it came to that. So that, again, just making sure that you're constantly looking at your jail population and following through on what it's telling you about who is sitting in custody is very, very important. Thank you, Hillary.
Yes, and I can echo that we did that the same team. When we were first implementing pretrial services, our target population was very small, and what we thought was that we would mainly deal with what we deemed those identified as low risk. But as we became more effective at that, we were able to see that now our jail population was mainly those felonies that Domingo was talking about, and we were able to build that confidence by reviewing that data, starting small, and identify another target population to target and to serve. A really great resource from NIC is the jail capacity planning resource. And I love this quote from them because it really is a good mission statement for your jail review team. I know I've seen some agencies, they have a jail population review coordinator. Some just use their CJCC as a jail review team. But your real job is not just to see who's in your jail and why, but also to take that data to examine policies and assess need and understand the effect it has on the jail and on your pretrial system, but also on your system as a whole. So that's kind of like your mission statement moving forward. But when we want to talk about the benefits of jails review, kind of bringing it back to a pretrial systems perspective, I know for my story and for many, especially rural pretrial programs, they're usually established in response to local jail overcrowding. And that was my story in Cass County in 2018. We had a jail that was over 35% over capacity. And that's initially how we started having some discussions about pretrial release. But continuous monitoring of that population is really a good way to help that pretrial agency ensure they're maximizing the 3 M's, which we all know that: release, public safety, and court appearance. And it also ensures, as Domingo talked about, that we are reserving jail resources for those who truly pose a risk to public safety, and that, like he talked about with his misdemeanors, that we are quickly moving out those lower misdemeanors, getting them back to their families and the resources in the community. And we're really making judicious, wise choices about our county's resources with the jail population. It also can promote collaboration. The jail population, and I find with jail data here locally, everybody has something to say about it, and everybody's system and the system map is impacted about who's in the jail and why. So it really can help spur collaboration and start a cultural shift, which is what our pretrial release program did in Cass County. It really started a shift towards making some risk-based determinations, not only in pretrial, but system-wide. I'll let Domingo share a little bit about how his jail program was created and the benefits that he's seen.
Yeah, absolutely. So, you know what, one of the things that, we worked on in Pima County, and, we weren't the other one. I think Lucas County, Ohio was working on a jail review program as well. And so, it involved that initial jail snapshot and then also recurring, information about the jail's population. Not only that, but we did have to get into, what are the aspects of the data that we're looking at? In our case, we not only included pretrial cases, but probation cases. And we, in addition to the populations that we were targeting, we had to make sure that we were able to, kind of keep a narrative on the data. And we'll talk about communication here in a little bit, and understand that if we are, addressing some of the low-hanging fruit, or some of the cases that are less, that usually don't stay in jail for a longer period of time, we're going to have data, and I'll talk about this in a little bit here, data on the back end that's going to look a little different. We had to make sure that that's part of the narrative. So, what we did is we looked at a population, felony population, through a sequential review process of individuals that were higher risk on a pretrial risk assessment, but possession type charges or property type crimes through a standing committee. It was a standing committee that reviewed cases with the prosecutor and defense in the room, but also included community members, service providers, and court and other administration. And it's an open to the public process. So, what happens in the meeting is that, these cases are reviewed and they go to the court. Eventually, if the parties agree, they should be released. And everything is captured, the data is captured around what the decisions are about, why someone wasn't agreed to be released, and then why someone was released. What are the things that our pretrial specialists and our pretrial officer who are assigned to our team, what are they looking at to help assure this person to make it to court? And this is, and really quickly, that's our first foray into a supportive services zone in regards to pretrial supervision, which I think is probably a lead into some further trainings down the road by NAPSA and or other entities. But yeah, that was kind of the basis of our program. Thanks, Hillary.
Yeah, and just to kind of take that further, the jail review also kind of takes you back some of the core missions of pretrial services. We all know that pretrial release programs are to help reduce the negative impacts of pretrial incarceration that we've alluded to, that includes separation from family and loss of employment. And studies show, many of you already know this in the audience, that even 1 or 2 days of pretrial incarceration can increase that likelihood of misconduct. So the implementation of a pretrial system also can help offset those sentencing disparities. I know for us, we had a lot of people before pretrial services entering guilty pleas, just as a means to exit jail. And if you want to dig in further, I won't talk too much on this slide in interest of time, but the next slide really just digs in deeper into more of those negative impacts of pretrial incarceration. Including that some are most likely to receive a harsher sentence because they're not out there helping their defense, exposure to more higher risk individuals, and also increased failure to appear rates. So those are some things that you can talk about with your team when you're talking about the negative effects of pretrial detention. But really, the jail population, before we move into the difference between a sequential bail overview and a jail overview, is beyond pretrial advancement. And I know for us, this is something I'm really passionate about. Your jail population can help you learn and discuss so many things. Like you can learn about your assessment practices and sentencing trends and diversion options, what supportive services that you need. A lot of times the jails are your biggest behavioral health center in your community because you have a lack of resources, and you can identify those gaps. For us, we looked at responses to violations because we saw the pretrial population was here and it went down. And then we had a lot of community supervision violators who weren't getting connected to resources. And that's why I have a treatment division now, because we wanted to identify ways to help them. You can see how community corrections and pretrial services is working. On the court side, you can think about timeliness of hearings, maybe crowded dockets. Maybe you need a magistrate to have more initial hearings to really expedite people and get out there quicker. Or also, are there barriers to release or to success on supervision? So I love this slide. I could talk about it forever, but I really want to dig into why is a sequential bail review different than a jail overview? And if we look at the definition from APPR, A jail overview is really a data-informed perspective of your whole justice system, and it identifies areas where you can improve, and it's your baseline of where you can identify those changes. So if we dig into that, the jail review looks just beyond the pretrial population. I think Domingo alluded to that too. We're looking at the effectiveness of our whole population, and we're looking at community supervision violators. We're looking at felonies, misdemeanors. We're also looking at admissions and releases. You know, you don't just have that static population, you have all the people who flow in and out of the jail and that affect the system as well. So if you think of the jail overview, it's a system-wide approach. And if you want to dig deeper, you can look at length of stay and risk level and capacity to identify those trends. Whereas if we're from the NIC's perspective, I think this applies to bail review as well. The key thing is that it's continuous. It's not a static one and done thing. So I think while everyone on the panel would recommend that you do that baseline analysis to measure where you are and so that you can measure that progress, the key is that you're developing a structured method to continuous look at that. If we move on to sequential bail review, the NAPSA standards, that's really where you're looking for those who did not initially detain release, but maybe are still in there and who could be released and why. So it's really is just a scoping down into that pretrial population, and we prioritize these sequential reviews so we can see if there's reasons that people are still being detained that might not no longer need detention, and to really kind of expedite the release of those people and make sure that no one falls through the cracks. So it's really digging deeper into that. When we talk about effective jail reviews, what does that really mean? And it has a lot of terms in the pretrial community. You hear it called as SPR, you hear it called a jail sweep or a look back process. But the key thing is a routine review of that pre-adjudication population. Most often, it's the responsibility of the pretrial services agency, and you're looking for ways to identify reasons the court may change that initial release decision. Are there any changes in the status or resources that the detention's no longer warranted? And this helps you make sure you maximize release, and it assumes that presumption of release, and you're really targeting to mitigate unnecessary detention. For our county and for Indiana, it's not just the responsibility of defense counsel alone. It really is an essential element that we detain. When you're communicating the results at SBR, it's important that we communicate it to the courts, prosecutor, the public defender. I communicate it system-wide, and I include information that is really about the pretrial length of stay, information on the detainees, their alleged offense. You know, are they have an outside hold? Is there a monetary bond? Case-specific information. We also expand that to include information on community supervision violators, so it really takes a system-wide approach. And you can also include the information in your updated report that may need to an updated pretrial investigation or updated risk assessment. I encourage you to dig a little deeper to see if referrals to supportive services, voluntary, of course, can help lower someone's risk level enough that they can be released successfully back in the community and get engaged in services so that they don't have to be detained. If we go to the next slide, a lot of people ask me, I know it's a big lift to look at jail data, but how often should jail reviews be completed? Really, the frequency depends on the resources of the pretrial services agency or the state agency, depending if you have a state jail review system or things like that. I would say that you at least need to do it monthly, but you really have to assess based on what your resources are. Start small and expand as you go. Just the key is to create a routine and systematic process for doing that, and this becomes a daily task that your agency does. And you're not just distributing information, you also want to make sure that you're taking action steps based on identifying these individuals that could be released, and that you're scheduling those meaningful review hearings, and that you're making sure that decisions are being made that benefit those in the community with this. if we look at reasons that, there may be a change in a release decision, and I find that my judicial officers don't think about this until I show them this slide, because they think that someone doesn't realize that the status of an individual may change while they're incarcerated. And one example I will say is my judge often said, I saw a $150 bond on this person and I thought they'd be out in 2 hours, and here they are 2 weeks later. So now every time she has another hearing, she checks incarceration status to see if what she thinks is going to happen is really going to happen. There may have been an outside hold, or they were serving an executed sentence on a concurrent case, and that's been resolved, and now there's no longer a barrier to release. Or they were able to secure a safe place to reside that may have been an issue. For us, we handle all medically necessitated release. Someone may need urgent medical care and it's just not an appropriate place to go through that in the jail, and that may warrant it. Behavioral health needs, or pretrial detention may have lasted longer than the sentence for the underlying case have actually occurred. So these are all reasons to take the time to engage in a sequential bail review, because no one wants to see someone held longer than they should have, or be held when they could be safely in the community and engaging in supportive services to help them lead a more successful life. With that, we're just going to kind of kick it off more into the jurisdiction examples. And so you can see how different counties or different localities actually do this in practice. And with that, I'm going to pop it over to Melana.
Thank you, Hillary. I want to just give an overview of what we do in the state of Kentucky as it relates to jail review. For those of you that do know, and those of you that may not know, Kentucky is a statewide pretrial services agency that operates within all 120 counties of the Commonwealth. And we have been doing such since 1976, when the bail bonding industry was outlawed in the state. And now I'm going to share some information about our jail capacity and pretrial population. According to the Kentucky Department of Corrections, we have 76 open detention centers or jails within 76 counties of the Commonwealth. Also, according to their data, the current jail capacity is at 21,104 beds, and that includes county level, federal, state, and restricted custody beds. As of March 27th, 2025, they reported that 10,007 of those beds were occupied by county level individuals. Of those 10,000 beds, 9,963 of them were occupied by pretrial individuals unable to be released from custody. And that includes individuals who have holders on them. Next slide. So now I'm going to talk a little bit about how we process individuals who come into the jail in Kentucky. So we have a pretrial services specialist team and a pretrial risk assessment team. We offer interviews to everyone who is booked into a local jail or detention center on bailable offenses in the state of Kentucky. We offer that interview, and whether or not the individual accepts that interview, they will all have a pretrial risk assessment conducted on them. And currently we use the public safety assessment for that. Once the interview is or isn't completed, and the pretrial assessment is completed, we then determine how that individual may be released from custody. The first way that they can get be released from custody is based on their charge and assessed risk level. If it meets a certain criteria, many individuals can be released on our pre-arraignment release protocol, which is an order from the Supreme Court, which allows our agency to release people on their own recognizance if they meet a certain criteria. So what happens to those individuals that don't meet that criteria? Well, we don't let them sit in jail needlessly. We would do judicial presentations for determining bail. And those judicial presentations should happen within 24 hours of booking date and time of that individual inside the local jail or detention center. But we don't let people wait until the 23rd hour to do that presentation. We operate 24 hours a day, 7 days a week, 365 days a year. If you get arrested and booked in on Christmas, we're there. If you get arrested and booked in on the 4th of July, we're there. And many people can get access to a pretrial service specialist within 30 minutes to an hour of being booked into the local detention center. We do most of our our bail presentations to our judges over the phone. We will call them. We also do them in person and in court. Like I said, we operate 24/7. We have 3 shifts, a first, second, and third shift for our pretrial risk assessors and specialists. And we have several jurisdictions where our judges will take evening calls. So we're calling some of our jurisdictions up until 10, 11 o'clock at night for bail decisions. For everyone else, when we do talk to our judges at least once a day, sometimes twice a day, to secure that release. In 2024, Kentucky Pretrial, we conducted approximately 126,358 interviews and risk assessments. And those are initial risk assessments. There are times where we may have to redo the risk assessment due to an error that we find, or someone that is currently in custody obtains new charges. From there, those individuals who are not able to secure release from custody, they will have a formal arraignment, and that varies based on jurisdiction. In the state of Kentucky, we have 120 counties, but we do not have 120 individual judges going into each of those counties every day. Many of our jurisdiction are 3 to 4 county judicial circuits or districts, and it makes it hard for a judge to have arraignments each day. But most of the people that are in custody will have an arraignment between 24 to 48 hours of being booked in. That does not count the weekends. We have one jurisdiction that will do arraignment court Monday through Saturday, and then one Sunday of the year, and that is the Sunday following the Kentucky Derby. However, if there's someone that remains in custody at the 24-hour mark, unable to be released from custody on bail, our pretrial staff is able to do a search in our case management system to bring up individuals who need to be reviewed with the local judge. At that time, we send information to the judge. Again, these can be done in person, and some of our judges like for them to be done in email. And we send the information to the judges to alert them that these individuals are still in custody, unable to get released from custody. And from there, they make a decision as to whether or not they're going to change that initial bail determination. So how do we do this? I've thrown out a lot of big numbers: 120 counties, 76 open jails, 21,000 beds. We have a pretty good system here in Kentucky to ensure that we do not miss people. However, it's technology and there's a human element to it all, and there are times that someone may slip through the cracks. But we do have access to most of our local jail booking systems. And those that we don't have access to, it's not because they don't want us to have access to them, it just may not be online. But regardless, we have an email system that we've worked with the local jails to ensure that we get all charging documents and booking documents for those individuals that are booked in. It goes to a centralized email server for our pretrial service specialist, and it enables someone that may be setting a pretrial service specialist who's sitting in far eastern Kentucky, where I'm from, to potentially enter that information and conduct a pretrial interview on someone that's sitting all the way across the state. We also utilize a system called Justice Exchange, which is a system where local jail booking systems feed into that. And we're able to get a bigger picture of who's sitting in jail. And if we did miss someone, if they have holders, when they were booked in, and also when they were released. And also, our Kentucky State Police has an e-warrant system that tracks all warrants that are served in any of the jurisdictions within the state, within the Commonwealth. That enables us that even if we do not get notification from a jail or detention center, or sometimes even a prison or penitentiary, that someone has been served with a warrant that we need to process, we're able to do a search and find those warrants and process those individuals for purposes of a bail determination. And as always, we have internal processes that ensure that staff are making sure that we are getting everyone that we can that comes through the jail that we're supposed to. That includes a look back period. So whenever you come back on shift, you look back a certain amount of hours or up to 24 hours to make sure that we've gotten everybody. Because we have a lot of systems in place, but there's always that potential that someone is going to fall through the cracks. But we do everything we can to ensure that does not happen. And furthermore, when that does happen and we find someone that we've missed or the jail's forgotten to give us the information, or so be it, our first call is to a judge to let them know, hey, this is what's happened. We're going to process them and we're going to call you as soon as possible. So we don't let individuals just sit until that next judicial call time to make sure that they get out or get a bail. We're constantly in contact with our judges and our jails to make sure that we're accounting for everything. And also, we are currently looking at implementing some sequential bail reviews, a little bit more in depth here in Kentucky. We have a program that we are currently developing for our pretrial supervision program that we are going to start building out, and part of that is going to be a sequential bail review to see who would be eligible for this program once it is up and running. So with that being said, I'm done talking about Kentucky, and I'm going to pass it over to Janice Dean.
Thanks, Melana. 126,000 assessments is a lot of assessments. That always strikes me when I look at your numbers. So thank you for coming this afternoon. I'm just going to give you a little background. So Allegheny County, it's Pittsburgh, Pennsylvania. Our local pretrial service agency is under court administration. Our countywide population is about 2.2 million, and our jail capacity is 3,223. Our current jail population as of last week was 1,849. Of that 1,849, currently we're at about 23% pretrial only. So that just includes people that are in with a hold without bail or a money bail that they cannot secure, but they've already been reviewed. So we'll talk a little bit about how we sort of start this process. So we have a central booking, and the majority of our pretrial assessment unit staff is located in our central booking area. We have 35 district courts that can do assessments during the daylight hours. So they're open really business hours. Our local booking center is open 24/7, 365. So the majority of our staff is there staffing that every single day of the week, 24 hours a day. We arraign every about 6 to 8 hours at that location. Our 35 district courts that can arraign during the day. Those offices have the ability to contact the pretrial office, and they can request an assessment. So then we will do that assessment and send it out to them. So, but about 85% of all of our, I can't talk and click at the same time. About 85% of all of our cases are seen at our central booking. So we conducted 15,964 assessments in 2024, and we presented 7,227 cases to court for our bail review in 2024. So basically, once someone comes into the booking facility, they're going to receive an assessment. Once that assessment is completed, that goes to the judge, and we have judge on site 24/7. And as soon as somebody's ready to go, we have arraignment times, But as soon as the judge has someone ready to go, they'll go ahead and arraign them. We do have our public defender's office staffs. They represent everybody at those initial bail hearings. So there is representation, for those people. So, we want to ensure that people are seen before that hearing by their attorney. And so the hearings occur between 6 and 8 hours after arrest. And once that hearing occurs, our pretrial program, so Pennsylvania for bail options still has money on the books. Our pretrial program since 2006 has not recommended a dollar amount. We don't recommend money at all. So we recommend either release on your own recognizance. We leave information for the judge if we feel that there are no condition or set of conditions that the defendant can safely be released. And then we have a whole supervision component. So once that occurs, people either leave if they were given OR or a non-monetary with some type of conditions, or non-monetary with no conditions. We also have unsecured bail and other non-financial conditions that can be set for them. At the initial setting of the bail, like I said, which occurs 6 to 10 hours after their initial entry into the booking facility, we do not let those magisterial district judges at that point use electronic monitoring. We did at one point, but it blew up, and so we stopped that. So that has to be done by a court of common pleas judicial officer. So once whoever isn't released, they go on a list. Our jail keeps the list for us through their offender management system. And so every morning we have access to the list of people that did not get released from the day before. We have an entire unit that screens those cases and presents those for court. So that's that 7,227 cases that we presented to court for people that didn't get out. So we review them the following day, and then they are scheduled sometime within 72 hours. So we have a local rule that those cases from our initial review have to be heard by a court of common pleas judge in 72 hours. We have one judge that we call them motions hearings, and we have access to him every day at 10 a.m. So our motions court is usually from about 10 in the morning till about 11:30 every day. And that was in addition. So we got one judge to agree to do it, and it was in addition to his regular docket. So we're really thankful that he continues to do that and initially agreed to do it. It's very helpful to have one judge. We have one district attorney and one public defender. So there's consistency in motions court every day. So like I said, these are set for bail with bail modification hearing within 3 days. So our numbers, basically what we did in 2024, we had 3,386 bond modifications. We also have a walk-in reinstatement program. So anyone who has any type of warrant, bench warrant, everything but an arrest warrant. So if it's a peer warrant, they can come to the pretrial office every single morning by 9 a.m. And then we take them to motions court every day at 10 o'clock. And again, we did a ton along with our sheriff's office advertising on this walk-in reinstatement, because it really is a safe way to get your warrant cleared, right? So you don't have to get arrested or anything. But those cases, we review those all the time on those, and periodically we'll contact defense counsel, usually through our Bar Association criminal litigation section, and say like, hey, listen, don't forget we have this, and then we'll have sort of a run on clearing these warrants. So the bond modification of someone who is not released can be requested by pretrial services, defense, or prosecution. So we take those requests from anyone. They occur daily with the same judge, Commonwealth Attorney, and Public Defender. And our local rule dictates that all bond modifications go to motions court unless it's a homicide. So even if the case is assigned to a judge. If it's not a homicide case, bond modifications all go to the same judge. And with that, we'll take questions at the end, and we'll try to answer some of your questions as they come in. But with that, I'm going to turn it over to Aaron Johnson.
Very good. Thank you. Thank you very much. Again, my name is Aaron Johnson. I am from currently here representing Galveston County, Texas. We are a smaller county, but we are very much adjacent to Harris County. Harris County is where Houston is. Houston is the third largest city by population in the United States. So even though our local population is about 365,000 people, we actually are a destination spot. So we host over 8 million people every year. So we have a lot of people coming back and forth between the beach, the port, a lot of back and forth, spring break. There's an event every weekend here, just depending on if the sun is out or not. So, and even then, it doesn't really matter. So we report directly to, we have what's called personal bond. And so some of you may recognize or call that something different. Own recognizance, supervised own recognizance, whatever terminology you might use, but it's basically we provide the service for trying to make sure that people get out on bond and then make sure they come back to court. So our jail capacity is 1,291. Our current jail population is 1,090. That's actually come down a little bit, and I'll explain that in a little bit more detail as we go through. So go ahead and go to the next slide, please. Uh-oh, Janice, did we lose you? There we go. All right. So the personal bond team is responsible for our pretrial assessment. So we have a pretrial assessment, and we have what's called a financial affidavit. So some of you may call that an indigency determination, things like that. So when somebody gets arrested and booked, we have a central booking area. Everybody is brought to the jail, and the personal bond staff are basically assigned to complete the financial questionnaire. Our personal bond team works really hand in hand with the magistrate clerks because they then turn their information, their interview information, over to the magistrates. The magistrates prep everything for magistrate court. We hold magistrate court twice a day. We see usually 6 a.m., 6 p.m. So we have assigned counsel just for the hearing. We're not assigning them counsel per se, but we do have counsel available for the initial hearings and the bail reviews that we do conduct. So that information is all available at that time as far as their assessment information, their financial affidavit, their criminal history. All of this stuff is made available to the magistrate court to make their decision. If someone is given a bond that they cannot meet, we have what's called bail review. It's built into the system. They come back 12 hours later to the next bail review, or excuse me, the next magistrate hearing. And we do initial hearings, we do magistrate hearings, and we do bail review all at the same time. If they still can't get out, and it's a misdemeanor case, we have what's called a misdemeanor jail docket. And that jail docket reviews misdemeanor cases who are still in custody after 72 hours of their arrest. And this happens only Monday through Friday. So that's based upon the availability of the court. The magistrate court happens 24/7 every day, 6 a.m., 6 p.m. We had a hurricane last year. We had COVID. All these things, the magistrate court still happened, right? So we're still legislatively, we have to make sure that these occur. So everybody that comes in the jail receives this. On the felony side, that is where my staff are actively looking for felony cases that when you come in for magistration, some cases are not eligible for personal bond, so they can't be released under our system. That now they're fine to be released under surety, but that's typically where people get tripped up and they don't have the money to get out. So the felony cases that are still in custody, our supervision staff are going back through Monday through Friday and trying to find a list of these people based upon the jail management system. And they will petition the attorney and the DA and say, hey, we still have this person in. They haven't been indicted yet, or maybe they have. And then they can petition the court that's been assigned to, or the judge that's been assigned to the case. Because once the case is assigned, the assigned judge has more flexibility in what type of bond and the amounts that the magistrates don't have. So part of our review process came out of being sued by the ACLU. We had what was known as Booth versus Galveston County. This is where the state got the financial affidavit. We had to make that determination of indigency before setting bond amounts. So with that, we also created what was called our coordinating council. And so this criminal justice group, made up of elected officials and department directors, gets together every month, and we are actively looking at the jail population as part of our routine meeting. And then we kind of branch off into some other things that we need to. But if you have a strategic plan in place, this is kind of the point of this this webinar, is talking about what you can do when you have something that is in place. So I'll go through some actual data because we had a crisis, if you will, here in the last few months. So go ahead and go to the next slide. So this gives you an idea. I put COVID in here because I didn't come to Galveston until 19. So this is part of a issue that I inherited and that we wanted to go ahead and make sure to move things along. As you can see, our jail population was already coming down, and then COVID happened. And then once post-COVID happened, we were actually operating under, when we first started this project, we were at 96% capacity. We were talking about building a new part of our jail. We were talking about farming people out. And that's when those kind of conversations start, that's when this kind of information becomes really invaluable. So as you can see, we got that back down to 77, 75. We were hovering around, really talking about, hey, is there something else we can do in our jail? But then roughly around October of last year, we saw our jail population starting to come up. And that was very unusual because usually going into the holiday, you start to see your jail population start to come down. And that didn't happen this year. So because we were already looking at this information, we were able to proactively start saying, hey, what's going on in the jail? Who's staying? Who's not getting out? And so if you go to the next slide, you can actually see when we started talking about this, we started developing a plan about, hey, here's where the change is. And it's not on the pretrial side. The pretrial side was still working as intended. We still have, 1,300 or so folks that we manage on a monthly basis. So we weren't seeing, there was no increase in the pretrial population increasing. What we were seeing is that probation, parole, immigration, and the folks who were waiting to be transferred to the state facilities, that was starting to back up. We were starting to get more of them. And so that gave us, hey, is this a Galveston County problem, or are other jurisdictions experiencing this? And when we called around and we called the state and we were like, hey, we're experiencing this. Is this the same kind of thing? Are there jail beds available if we have to have a variance and be moving people around? And we were told this is happening statewide. So it was good to know that information, because now that presents a different problem that we then have to try to address, because knowing that there's nowhere to put extra people, it forced the coordinating council to look at their own processes. So not only was pretrial, providing these interviews, going back into the jail and looking, it forced the DA to look at their cases and to try to move cases along faster because they knew they would need to. The judges were on board with trying to get cases moved faster. The sheriff was paying attention and looking at who was being brought to the jail, who could be released under their authority. So it really took a system-wide response to get our population back down. So the slide, I believe this information was through December. Last month, we actually got everything back down. We're actually back under 90%. So it's not so much of an emergency, but if you're not doing this, it just speaks to how quickly something can escalate. And all of a sudden you find yourself in a uh-oh kind of situation versus trying to be proactive and move things along. So I think that's my last slide. So with that, one more, sorry. There we go. So for all the cases that are in, this is just an example of the email that we send and who we send it to. So once we identify somebody, hey, this individual meets this criteria, here's their charge. If you would like to release their personal bond eligible, we would supervise them. And then, it basically goes to the district attorney assigned to the case, the attorney that's assigned to the case, if there is one. And then it also goes to the judge that's assigned to the case, if it has been assigned, if it's post the magistrate process. So this coincided with the DA kind of getting on board, and then all of a sudden, okay, are we actually going to go through with this case? Is it going to get dismissed? Are we going to decline it? All those things started to move faster when everybody was responding, kind of pulling in the same way, understanding that the jail population is what it is, and we weren't going to be able to move people. So we need to adapt and move our process a little bit faster. So I believe that's my last slide. And I'll go ahead and move on to Hillary. But we'll take questions here at the end. So if you have any other questions, make sure you're putting them into the Q&A.
Aaron, really quick. You have a Q&A and you have a Q&A asking if you could share the final form that you developed in Galveston.
Yes.
Oh, I see.
I was just going to tell you.
Perfect. The final form in regards to which part? Past that, yes. Any of my information, any of the information that we share today is public information. So I'd be more than happy to send whatever you may need. Oh, hey, Deidre. That came from Deidre. Very good. Hey. All right. There we go.
Okay, so in Cass County, we have a standalone pretrial agency that's actually a county department. We're also court services, which means I get the lovely privilege of also kind of helping oversee all the community supervision agencies as the chair of the CJCC. We're a rural jurisdiction, and I'm proud to really represent the rural agencies out there, because I know jail data can be really intimidating to rural agencies because we wear so many hats, and it's really hard to dedicate time to this important practice. But I loved the last two slides from Aaron, because those situations happen even quicker in rural agencies, because we're armies of one. Our local jail is now a capacity of 307. But our average capacity in the jail, thanks to the work of the pretrial staff, is only 60%. But to kind of show you, without pretrial services and the impact of our supervision, our average capacity would be 110%, even with that new jail that we just built. If we move to the next slide, a little bit about our practices is that pretrial services staff interviews every person that's booked into the jail within 24 hours of their arrest, and we evaluate them using the IRAS-PAT, or many of you may know that as the Ohio risk assessment, and that's the validated risk assessment that we use statewide to measure their risk of failing to appear or reoffending. We hold meaningful first appearances every day, but we try to expedite release. So anytime probable cause is determined, we try to get in there and get our pretrial assessments done at that time to see if we can do a bifurcated hearing, where really we're just kind of seeing if that person is lower risk, is a misdemeanor case, that we can expedite them out sooner, even before a meaningful first appearance. So in that way, we're really trying to get in there, and at 2 times, really trying at that initial decision point, expedite the release of people who are appropriate to release. Our local Justice Reinvestment Council, Indiana, calls it JRAC as their version of CJCC. That also serves as our jail review team. Myself, the director of the Pretrial Services Agency, I'm kind of the jail population review coordinator, and I am the one that's responsible for continuously analyzing the jail population and conducting that SBR. This next slide is just really kind of a timeline of how that happens in our agency. it needs to be updated because I now really start screening people depending on how many people were booked into the jail the day before at about 5 a.m. or 4:45. And then I will go in there, do all those assessments at 5:30 after I've gathered all that collateral information. All those recommendations are sent to all the parties by 7 a.m. usually, depending if we have a bigger day, so that the prosecutor, public defender, and the judicial officers all have a chance to review those recommendations before that hearing at 8 a.m. So between 8 and 9 a.m., we are having those PC hearings, trying to expedite people out of the jail early. So a lot of times, to give you context, someone could have been booked into the jail at 6 a.m. I would have went back in between I started at 5, reassessed them, got that assessment to all the parties. We had that meaningful first appearance at 8 a.m. and then they were released by 9 a.m. So that's a quick way to do that. If they need supportive services, they can come to our office and we're connected to the jail sometimes 9:30, 10 a.m. Get connected to those supportive services all before their initial hearing. So we try to move really fast in Cass County. Which is why we just try to really expedite that release, meet those needs, and connect them to supportive services to help them be successful. When it comes to our jail review, I'm in the jail every day. I have full access to our jail management system. So I really try to monitor that, but the full jail review and sequential bail review. So we do both a jail overview and a sequential bail review on a monthly basis. This is all in addition to bail reductions and promotions for higher than standard bonds and special conditions, because those are also different pathways for someone to be assessed for us. We've expanded this. Previously, those who were held with no bond, maybe on community supervision violations or failure to appear warrants, they also now can be assessed so that we can ensure risk-based determinations at every decision point in the pretrial stage. All new arrests and jail admissions are reviewed daily to identify people to be assessed. We have no offense-based exclusions. So I take everything from misdemeanors all up to level 1 felonies. If they are eligible for bail, which everything but murder and treason is eligible for bail in Indiana, we are in there and assessing those individuals. The results of the jail overview and the SPR, they include not only, they're for the entire pre-adjudication population, but also for community supervision violators. And they include information such as the time that person has been held in jail, that pretrial length of stay, all pending cases locally, and also out of county if we have that information, the leading charge information, the assessed risk level with our IRAS PAT, any holds that could be a barrier to release, and any other necessary case-specific information. We do this in an Excel program that we have built here locally, an Excel sheet, and it's programmed that anyone that's held more than 90 days, that they are highlighted in a color that escalates every additional 30 days that person is held. So when that public defender or prosecutor gets that information, that they can quickly see those cases that are the higher priority for them to look at. If we go to the next slide, this is kind of a really simplified version of what that Excel sheet can look like for you. So I don't have any fancy program that I use to manage my jail data and do that. We have a very archaic system, which means if your program is lower resources and rural, that means you can still do this too. I built this in Excel, but these are the basic elements that I would recommend that you do in addition to the email process that Aaron showed. We do that as well. We send those emails out when we identify those people. Maybe a hold is lifted and they're now eligible for pretrial release. We do those emails, but then we also send out all the raw data as well. And we break that down by court. So each judicial officer will get an Excel sheet with all the information that I shared. It's a little bit bigger than this, of all the cases in their docket that are still detained pre-adjudication or with the community supervision hold, with all that information. And then attorneys get that individual basis information as well. Our chief public defender, she gets all of it so she can capture everything that may have fell through the cracks. When we're looking at communicating the jail overview, when you want to engage your stakeholders, I do a monthly jail newsletter as well that I send to our CJCC and our community partners. So it provides some visual information as well as some narrative about who's in the jail is why and the impact of pretrial services on the jail population so that they can quickly see what's going on in the jail. Because like Aaron said, from month to month, it fluctuates and we really want to be proactive in how we do that. If we move to the next slide, you'll see here just the impact that pretrial release has had on the pre-adjudication population. So prior to pretrial services in 2018, our baseline data, our average jail population was 234 individuals, and that was about 46% over capacity. Today, our average population is about 119, and we are 39% over capacity. So by incorporating jail review into your pretrial operations, you can really change the landscape of your criminal justice system. And to kind of dig a bit further, when we look about to the next slide, you'll see I kind of illustrated that, that we also were able to reduce our pre-adjudication population before implementation of pretrial services and our jail review project. Pre-adjudication was 70% of our jail, and now we keep that between 10 and 8%. And we really continually look at this data as we move forward to just continually try to expand our program and meet the changing needs of our community. And with that, we want to answer your questions and get your feedback. All of our contact information is up here on the screen. But we just would welcome you to throw any questions in the question and answer section. And this time is for you so that we can answer those and work through that together as a team to really help you take this information and apply it to your jurisdiction.
So there's a question for defendants who aren't eligible for bail under a schedule. So the question, I'm not really sure because you shouldn't have a bail schedule because they're illegal. But I'm not sure what you're talking about. So everyone should be eligible for bail, except for usually capital offenses. Some ours is capital offense. You're actually still bailable. We still interview people that have homicide cases because at its first listing at a preliminary hearing, maybe charges are reduced. Maybe that wasn't the person. And then we have that already completed and ready to go. We could just update it with charges. So I'm not sure. Is there a role for pretrial services in facilitating their release before a formal court hearing, for example? Aaron, did you answer that already?
Yeah, I was just going to say, I agree. The bail schedules, if you're still using them, I would caution you because you're inviting groups to come in for lawsuits. But everyone in most states that I'm aware of, that I've worked with, there are some usually pieces carved out that are not eligible for release. And maybe the question, it might be more along the lines of eligible for a certain type of release, whether it's cash surety or cash, whatever it may be, pretrial. I think that the conversation should steer away from, people are not eligible to be released pretrial because that systematically should not be the case.
Yeah, I think even if maybe by either local exclusion, there are places that have local exclusions that we have a couple jurisdictions in Pennsylvania that if it's a weapons offense, they don't want pretrial to even look at them. We would still do the assessment. A judicial officer is going to do what they're going to do. I would recommend for your pretrial department to assess everybody.
Yeah.
When you're doing that.
Yeah, and I would say even if someone's not eligible for bail or is not, if there's a constitutional provision or law, typically speaking, the prosecutor needs to argue to the court why that person should not, be granted bail at all. So I think that answer to that question require more information on what is exactly the schedule you're talking about in your jurisdiction. And there was,
Renee has a question.
Yeah, there was another question earlier, and I kind of wanted to talk about that. It was about about FTAs, and like how long, in our county, defendants who are picked up on a KPS for failure to appear sometimes wait 2 to 3 weeks in jail. So, this is actually a very good question relative to this conversation about, who is in your jail. And I mentioned earlier in the webinar that, you know, um, there was a misunderstanding about who was in our jail, but one of the populations of individuals, the set of populations was misdemeanor failures to appear. And so that we were able to look at our jail population and then look at the length of stay. They weren't staying 2 to 3 weeks in jail normally. They were, staying a little less time in jail, but it did create a process and a program for us to administrative order to address cases before they were actually booked into jail if they came in on an FTA. So we did use that jail population review, the jail snapshot, to kind of substantiate the need for a misdemeanor release program, and that was one of our main strategies to reduce jail population, especially with low risk cases or low charge cases. I would say 2 to 3 weeks for a low level misdemeanor it seems like a long time, unless there's like a DV, domestic violence charge attached to that. But other people have different experiences.
And I would
Yeah, in Pennsylvania, we have a statewide rule that if you get arrested anywhere in the state on a bench warrant, you have to see a judicial officer within 72 hours. And so that usually spurs, if the bench warrant is from our jurisdiction, then our judge can, of course, address it. If it's from another jurisdiction or another state, that then leads us to either contact the DA for extradition so they can start the extradition process, or we'll contact the sheriffs to contact one of those other in-state jurisdictions to see, like, okay, this person's here, you need to come get them. And so, we do try to facilitate that.
Yeah, and I'll piggyback off what Domingo said. We used our jail review team to really look at the population of FTAs in the jail, and we combined that with the new research that most FTAs are not willful. So we've developed alternate responses to FTAs. So we looked at it at the front end to make sure we're not blanketly issuing warrants to everybody, but for those who are picked up on a failure to appear warrant, any type of warrant that someone's picked up for in our county, and we also have a rule similar to Pennsylvania as well. We see those every day as well, in addition to the meaningful first appearances. So we try to adjust those quickly. And the judge also can call us in to do assessments on those who have failed to appear, because we want to make sure that we are recognizing that most failure to appears aren't willful, and that if that was the case, that we can expedite those out as well. Or maybe it was willful, whether it was or not, maybe they can be safely released back to the pretrial services agency. So that was another program that came as a result of looking at that, and we were able to reduce the amount of FTAs that are held in our jail by 50%. It's usually just about 12% of our total jail population is held on an FTA warrant, and those are for some pretty high charges and someone who's absconded for a long time.
Yeah, and to add some statistics regarding our misdemeanor population, when we looked at and created our misdemeanor release program, before we did that, it's a pre-booking release program. About 15% of our jail population was misdemeanors. Many of those were failures to appear. And now the percentage of misdemeanors in our jail is 5%. So there was a significant decrease in the number of misdemeanors. There was another question, and I probably need to talk about this. Curious if other pretrial agencies automatically disqualify pretrial supervision defendants who are homeless and cannot provide an address to the court. And I mentioned that, unless it's in your statute, if there's detention in your statute and it describes that homelessness is part of your statute, which I'm not aware of any states that have that, it should not disqualify anybody if they're homeless. In fact, that's probably a target population if they're struggling getting to court. As a pretrial organization, I would say, we have interview-based data and demographic information on defendants that we get, from a neutral perspective. If you're able to overlay, if you do a jail review, if you can overlay that information and find that, you have many homeless defendants who are being held in lieu of a bond, that's probably a population to move quickly on looking to develop release strategies, given that it may be a legal issue if you're holding people simply because they're homeless. So I would actually, include your pretrial collected information if you have it to make an argument for that being a population that needs to be addressed immediately.
Up on the screen is a QR code for a evaluation for today's presentation. So if you would be so kind to complete that, we would really appreciate it.
All right. I don't have any other questions that have popped up at this point. So Wendy, if you want, I think we're good to go ahead and finish up.
Okay, great. If there are any of you out there that still have a couple of questions, feel free to put those in the Q&A. We do still have a few minutes. But otherwise, if we don't see anything come up in the QA, just wanted to give you a final thank you for attending. Thank you so much to our panelists. One of the things that not to mention just the expertise in the room makes me so happy, but also it makes me so happy that we had such a diverse population as far as people from throughout the country, from large jurisdictions, small jurisdictions, statewide, county level. So hopefully you were able to take something back with you today from someone who has a program similar to yours, or maybe even learn something from a program that's very different from yours. Really super thrilled to have you here. Again, our next session that we'll be having is on accreditation, May 21st at noon. Excuse me. I put that in the chat, and so you can look there in the chat for that. And then also we'll be putting out soon registration information for our conference that will take place in September. So just a reminder about that as well. If you are a member, thank you so much for being here with us today. Thank you for joining. And if you're not, please consider membership. We're really doing a lot of great things. We're innovating right now and really building. And it's an exciting time, I think, to be part of NAPSA. So consider joining. And just wanting to make sure, I see a whole lot of folks saying thank you, wanting to make sure from our panelists, are there any other questions outstanding?
Not at this time.
Okay, I do see one just asking about the presentation. So we will upload the video we were recording today. You probably got that notice when you joined. We will upload that to our YouTube channel, and so you'll find it there. Typically that takes me a day or two to get that up there. And then I will also send that out via email, as well as the slide deck will be in the same email. So, and if you don't receive something from me, my email I put in the chat, but it is exec.director@napsa.org. So it looks like the abbreviation for exec director@napsa.org. All right. Thank you all and have a wonderful day.